In recent years, there's been increasing concern over protecting a company's IP assets, whether it's due to rapidly changing technology or the rise of sophisticated counterfeiters. More and more companies are finding themselves in perplexing IP situations. Joining me now to discuss managing the impact of those situations in the court of public opinion is Marcia Horowitz. She is a counselor and publicist at Rubenstein Associates and heads the firm's crisis management group, financial group, and its law firm practice group. Bloomberg LP, the parent of Bloomberg Law, is also a client of Rubenstein. Welcome to the program, Marcia. It's so good to see you again.
Well, Spencer, it's nice to see you too.
So I read that you said protecting your corporate IP assets can sometimes be a double-edged sword. What did you mean by that?
Well, I can give you two examples. There's one example which is actually in the news now. There's Yves Saint Laurent and Louboutin are at odds with each other of what they call the Chinese red soul.
Yes, I've heard of that.
Yes, and it's gone back and forth. And actually, Yves Saint Laurent was the last time was triumphant, where the court had said that you really can't copyright Chinese red soul. We had a client before that ever happened who had thought of making a Chinese red soul, knew there was going to be a problem with Louboutin and decided not to do it because they did not have the staying power, they did not have the money, nor do I think they had the guts to kind of really go up against Louboutin.
Such a big company.
That's exactly right. So they, because they had those considerations, they opted not to do it. They'll see and watch what happens with this case. If Yves Saint Laurent continues to be triumphant, probably be a lot of shoes that will have red soles.
Yes.
Right. On the other end of the spectrum, we represented American Eagle Outfitters, which when we represented them quite a while ago, they were not well known at all. And they had decided to come out with a sweater that was one color and then had two stripes across the top. And they knew they were going to have a problem because the sweater looked very much like an Abercrombie and Fitch sweater. However, they made a concerted decision to go ahead and make those sweaters, knowing that there was a good chance that Abercrombie would go after them.
Did they?
Well, they certainly did.
Okay.
And they welcomed it because here we were, the little guy, and here we are with our great saying, how can you copyright two stripes on a sweater?
Right.
So we actually won in the court of public opinion. The press was very much in our favor, and we looked like there was the 800-pound gorilla. And we also won in court, which also helps.
So it could be both fruitful, but also it can also be damaging then.
Yes.
So that's the double-edged sword
absolutely.
component of it. So what's the first question, the very first question that corporate counsel should ask themselves when confronted with an IP situation?
Well, the question is, do you want to go forward with it? Do you want to settle? Do you want to get the team together, the people who are the decision makers? That's the executives, that's the PR people. Often you'd bring in outside IP counsel. Since everything that has happened with piracy and the American Invents Act and all of the technology that is happening now, things become much more complicated, and it's not really so clean-cut on whether you're going to win or whether you're going to lose a case, and how much you really want to invest in it.
So once the company is actually faced with litigation, should it convey some type of a message to the outside world, to the public? And if so, what communication tools should they use to convey that message?
There's many tools. I mean, you can certainly go to the media. You can certainly start putting things up on YouTube, putting up a visual if indeed there's consumer confusion and showing that there's no consumer confusion. You can use Twitter. You can use Facebook. You can try to begin a viral campaign where your point of view is pushed out into the media.
One very famous example, I guess a popular example, press conferences too.
Yeah, press conferences, you don't even have to do them so much anymore. You can make your own press conferences where you have total control, put it up on YouTube and tell everybody else where it is. Absolutely.
It goes viral.
Yes, it does go viral. You can't control how viral it's going to go, but you can certainly try. And then you would sit down with print reporters and you would speak with them. The one thing that does happen, and this happened in another case of ours, where there were two perfumes, and the packaging on the perfume could have been construed as being confusing. We didn't think it was. The other company had gone to the patent board saying that they were infringing. We told our client, really, let's go ahead of it. Let's talk about this. Let's get it up there and show everybody that this is really no consumer confusion. No one would mistake these two perfumes. And actually, they lost. We lost. And apparently, it was found that there was consumer confusion. So while we had all the great publicity we had, the perfume was already in the stores at Christmas time, and none of the department stores could sell them.
Oh, wow. So Marcia, though, tell me this. How do you decide whether to publicize an IP-related lawsuit?
Well, That, again, there's all kinds of things that go into that. I mean, a lot of people believe that publicizing it, if there's going to be a court case, there's going to be a jury pool. A lot of people think that the more you get out there on your side, the more you may be influencing the various people who would be listening to the case, shareholders, employees, other people, to make them think that you have a strong case. We have a client now, which is a breakfast treat cereal. There's another cereal where there's similar names in both of them. We had said to them, well, we think you should go out forward with this suit. We think you have all the rights on your side. And they decided not to, because they always want to leave the door open for settling.
Right.
And if you get too harsh against your opponent, it becomes harder for you to settle the case.
Settle that case.
Right.
Well, and I guess in conveying the message that we spoke about earlier, too, is it advisable that in-house counsel and the corporation, they seek assistance from outside public relations practitioners like yourself? Mm-hmm. And then sort of conveying that message earlier. It
all depends. There are some times.
See, I thought you were going to say yes, absolutely. You surprised me there.
It depends. A lot of times, a company will feel that if you've brought in an outside PR firm, you have a problem. So they'll think maybe the in-house counsel or the in-house PR person should be the one who should be the spokesperson. However, in many of the cases, especially in IP, when things are very complex and one has to be very careful on what's said, and if there's litigation pending, they often like us to handle the calls from the reporters. We're very used to it. We're very adept at it. We're careful about what we say. We represent a lot of law firms, so we know when not to say things. We know which reporters we can trust to go on the record and off the record and on background, because it becomes very complicated. So every case, there's a case-by-case basis.
Case-by-case.
Absolutely.
Well, and what's a great way, once you're in the midst of litigation, what's a great way to broaden the theme, so to speak, of the litigation while still advancing some business goals and interests of the company?
A lot of times, third parties are very important. If you can get third parties who are disinterested but can opine on the subject matter and certainly hopefully opine in your favor, it becomes very powerful. Often we'll go to professors or people who used to or retired, let's say elected officials or others, depending on what we're talking about. We can go anything from trade secrets to counterfeiting to trademark infringement. Any kind of expert or any kind of third party that is impartial but is certainly on your side in terms of the merits of the case.
Okay, and you've stated that most companies, if not all, should have a crisis communication program.
Right.
So what are some key elements, key components of a good IP-focused crisis communications program?
First of all, to form a crisis team. Oftentimes, you don't know when there's going to be a lawsuit against you. A reporter will call you at 5 o'clock and tell you have 15 minutes to respond. You've got to have a nimble team that is emboldened with making decisions. That will often include somebody high up at the company, general counsel at the company. If it's an IP issue, again, outside IP counsel might be very important who understands the issues. And, of course, you must have an outside PR person and an inside PR person. And within that group, formulate a response that won't imperil your position, but at the same time, you won't be caught saying no comment.
Okay. Well, and I have to say that having this program then would allow the corporate counsel to better manage the impact of certain IP situations, correct?
Absolutely. And, rule number one is often to remind all the people in the company that the media policy of the company is not to speak to reporters, because reporters will go to every level.
I was going to ask you, how do you deal with media calls during litigation, and are there best practices for media calls?
Companies should always have a media policy in place, not put one in as a knee-jerk reaction because something has happened, that the policy is that nobody in the company speak to the media, that all calls should be referred to, let's say, the in-house PR person, and that it is the policy of the company that only the in-house PR person speaks to the media.
Is it also good to have those statements written because it allows you to be consistent, to keep a record of what was said, and then also to avoid any extraneous conversations?
Absolutely. And when there is a litigation, it's okay to say, listen, especially in a print reporter, I don't have the answer to that question, but let me get back to you. The one thing that you don't want to do is give a knee-jerk reaction because you think you have to, and you're giving a reaction that the lawyer, after you get off the air, will say, you really shouldn't have said that. That's not going to help our case in court.
Yeah, and after the case ends and litigation's over, is the post-litigation statement just as important as any other message conveyed during litigation?
Absolutely. It depends, of course, on what the end is. If it's an amicable settlement, everybody will praise everybody. everybody else. If there is a case where there was some monetary settlement or whatever, most of the time, if there's a settlement, you want to take the high road. Okay, you want to go, you want to commend your adversary, but you will want to move forward in a positive way.
All right, well, we're going to have to leave it there, but thanks, Marcia. There's some great tips there for in-house and outside counsels, so we really appreciate you joining us today. Thank you.
My pleasure.
Rubenstein's Marcia Horowitz. For more information on this or other topics, log on now to BloombergLaw.com. I'm Spencer Mazyck, reminding you to be in the know with B-Law. Bye, everybody.